Okay, this is the 140-160 class. This is Monday of week 1, and it is April 3rd. And we are going to begin practice with an admonition. For the record, I appreciate it if you would try to answer out loud and try to answer yes or no. At a later time, it will be put in the form of a booklet called your deposition, and you will have an opportunity to read it, and you will be asked to sign the booklet. At the time that you sign the deposition booklet, you may make changes in it. But if you do, it could be commented on by an attorney at the time of a hearing, and it could weaken your case. It's to your advantage to give your best answer here so that you won't have to make changes later on. You will have the opportunity to, should you need to. If I ask you something that you don't hear or you don't understand, please ask me, and I will be happy to repeat it or rephrase it. If you do answer a question, I'll assume that you understood it. You understand that you are under oath, and that oath has the same force and effect as if you were in a court of law. Do you understand what I just asked you? Okay, this is a motion for a continuance on the record. Ladies and gentlemen, after considering all of the evidence presented, the court finds and concludes as follows. First, that the court has jurisdiction over the subject matter and of the parties involved herein. And further, that the court has recognized that a proper and timely appeal has been filed. I have scheduled a hearing on this matter for September 10, 2011. On June 11, 2010, the parties filed a motion for continuance requesting that the hearing be continued due to unforeseeable issues affecting both plaintiff and defendant. Opposing counsel was notified of the said motion in a timely manner. Upon examination by the court of the reasons set forth in support of Party A's motion, the court has concluded that the instant motion for continuance shall be granted and that the hearing shall be rescheduled 30 days after such event, that being September 10, 2011. All parties involved will need to jointly contact the court to obtain any further information on the motion for continuance, which is hereby granted and recorded on the record. Please file these documents, Mr. Clerk, with the judge in Department 43. Okay, now we'll do a stipulation on the record. Can we stipulate to attach the photocopies to the deposition? I propose that the original be forwarded to Mr. Pell, who will undertake the responsibility of having Mr. Castle read, review, and correct, if necessary, the entire booklet. The booklet can be signed under penalty of perjury. Mr. Pell will notify me of any changes in the booklet within 45 days after it is received in his office from the court reporter. Anna, you are relieved of any responsibilities under whatever the proper code section is, and if the original is lost, misplaced, or not signed, a copy can be used for any purpose in lieu of the original, as if signed under penalty of perjury. So stipulated. Further stipulate that the pictures that were referred to, that the originals will be returned to Mr. Price, and they will be attached to the deposition. It will be a copy of one page, with the top photograph being Exhibit A and the bottom photograph being Exhibit B. Okay, this is some literary material. It is congressional, for the record. Perhaps the most compelling reason for enacting this amendment is presented by the alarming lack of dental care now available to America's children, particularly those in low-income families. By age 2, 1/2 of this country's children have decayed teeth. By the time he enters school, the average child has 3 decayed teeth, and by his 15th year, he has 11 decayed teeth, missing or filled teeth. More often than not, these are 11 decayed or missing teeth, since over 1/2 of all children have never been to a dentist, and that proportion is even higher in rural areas. By far the greatest need is among children from low-income families, the very children who would be served by the pilot projects served by the legislation. Almost 70% of them have never received a dentist's care. My bill will provide the immediate treatment and diagnosis which is necessary to meet the dental needs of these children who have in the past had the least access to good dental care. These programs, along with the provision for community water fluoridation included in the committee bill, would be the best possible preparation for the dental health care provisions of any national health insurance bill finally passed by the Congress. The provisions of this amendment, while directed primarily at children, are guarantees for the future. Through effective prevention and basic dental health education programs, the future dental health of our nation can be significantly increased. Okay, this is some more congressional material for the record. Mr. President, I noted yesterday I would be coming to this chamber. I will take a moment, if I may, to provide our colleagues with a short update on the circumstances involving the Senate today. This has been a trying time for all of us, in particular for my office and staff. I am thankful for the outpouring of concern and support we have received, especially from the family of senators. I am very grateful for their friendship, for their words of encouragement, for the strength they have given me and my staff over these very difficult days. It has meant a lot. I wish to thank as well the many experts who have come to investigate and to help. I wish to recognize Senator Thompson, Dr. Ken Moritsugu, Deputy Surgeon General, all of the Health and Human Services staff, Dr. John Eisold, our attending physician of the U.S. Capitol, and all the physicians who are working in his office. MG John Parker of the U.S. Army, Dr. Greg Martin, who has been unbelievable and incredible help to my staff, to me, and to the entire Senate during this time. There are a number of professionals who work with Dr. Martin at Bethesda Naval Hospital, whom I want to recognize as well. Were it not for their effort, we would not be in the position we are today. They have been working around the clock, analyzing the thousands of tests that were taken. Though they are not in the Capitol compound, they have had every bit as much to do with our success in dealing with these circumstances as anyone else. So we are extremely grateful for them for their work. I want to thank as well the Centers for Disease Control, including Rima Kabaz and Ali Khan, the District of Columbia Department of Public Health. Finally, I thank the members of the Senate family who have been working around the clock to address this situation, to coordinate our response, and to see to it that the Senate was able to continue its important work. Maybe first among all of those, I thank our Senator of the Senate and our Sergeant at Arms for their outstanding work. There were several nights where they literally did not go to bed. They stayed up the entire night working to be able to address the many challenges we were facing as we looked at the logistical and health concerns people had. I also wish to thank Dr. Bill Frist. He was in the chamber earlier. He has been an amazing resource. While he is not present now, I know I speak for all of our colleagues in thanking him. He again spoke for all of us in a news conference wherein he was able to answer in very understandable ways many of these complicated questions. So I personally thank him, and I know I speak for everybody in thanking him as well. The challenge facing all of these people and all of us is unprecedented. To a person, every official I have mentioned has responded in the most admirable way. Their poise, their professionalism, their compassion have been a comfort to all of us, especially to my staff and me. I want to provide an update on where we stand based on Dr. Moritsugu's briefing a few moments ago. It is now 72 hours after this incident occurred, and we now can say we are confident about the health of the public. Beyond the 31 positive nasal swabs I reported yesterday, the results on nasal swabs analyzed to date have all, and let me emphasize all, come back negative. The CDC has determined no further nasal swabs are needed. Tests on all of the nasal swabs collected on Monday will be completed by the end of today, although we may not be in session, so I chose this moment to come and give at least this partial report. A total of 278 swabs were taken Monday. At this time, there are no further positive results, so the number of positive results to date remains at 31. Everyone who has tested positive has been notified by medical authorities. Let me put some rumor to rest, because it has been circulating all afternoon that some member of the leadership has been provided with a positive test result. The unequivocal clarification in that regard is that story is not true. There is no positive result among any members of Senate leadership. Testing also continues on approximately 1,400 swabs collected Tuesday. Of those, preliminary results on approximately 600 have produced no new positives. To this point, the CDC investigation has established the exposure area as the 5th and 6th floors in the southeast wing of the Hart Building. Based on this determination, the CDC has said no further nasal swabs are needed there. People who were on the 5th and 6th floors in the southeast wing of the Hart Building on Monday are being reminded to complete their full 60-day course of antibiotics, regardless of the result of their nasal swabs. Anyone who has entered that area but has not received antibiotics should report to the treatment center at the architect of the Capitol facility on the southeast corner of 6th and East Capitol Streets. A thorough environmental sweep of the Capitol complex began last night. It went on throughout the night and continues today. Those sweeps were conducted by the EPA and the National Institute for Occupational Safety and Health. Areas were swept in the Capitol, the Dirksen Senate Office Building, the Ford House Office Building, the Capitol Police Off-Site Delivery Center, where all Capitol mail and deliveries go through security screening, and at this time there are no additional results to report. The sweeps will continue, as we reported yesterday, over the next several days of the other areas of the Capitol complex. The entire Capitol complex will be swept, and so there will not be any area left unattended or unchecked before we are cleared. Numerous additional samples have been taken of the ventilation systems, and these samples are under evaluation. I think it is important to emphasize, too, at this time, there is no evidence of contamination in the ventilation system. Because of the extensive work being done, it is not clear when the Hart Building will reopen, but it will reopen as soon as we are absolutely confident it is completely safe. I want to make one final point. The people who work in these buildings, regardless of their political affiliation, have come to the city and to the Congress because they believe in what this nation represents to its citizens and to the world. Many have made sacrifices to do so. Some are accepting lower pay than they would receive elsewhere. Many are far from their families. All believe that by being here, we can improve the lives of Americans and in the process, make America stronger. The letter may have been addressed to me, but these attacks didn't strike just my office. They struck at the heart of that belief. In the past couple of days, members of my staff who have every right to be afraid, who have every right to take some time and be with their loved ones, have come to talk to me. More than one has told me they were more proud than ever to show up for work. This attack was meant to undercut that spirit. What I have seen in the past 3 days is all I need to know that the attack has missed its mark. I yield the floor. That was at 160. Okay, this is some jury charge material, and this will be at 170 words per minute for the record. Ladies and gentlemen, you are the sole judges of the facts. I cannot comment on the facts. You are the sole judges also of the credibility or believability of the witnesses. I cannot give you my opinion on whom to believe, what to believe. To do so, either by facial expression or tonal inflection, would constitute reversible error. That is your province, and I do not intend to invade it. Murder. It is the unlawful killing of any person with malice aforethought, either express or implied. In order to convict this defendant of murder, the state must not only prove the killing of the young man by this defendant, but that it was done with malice aforethought, and that proof must be beyond a reasonable doubt. Malice is defined in the law of homicide or murder as a term of art. That is, it is a technical term importing wickedness and excluding just cause or excuse. It is something which springs from wickedness, depravity, from a depraved spirit, from a heart devoid of social duty and fatally bent on mischief. The words express or implied do not mean different kinds of malice, but merely the manner in which the only kind known to the law may be shown to exist. That is either by direct evidence or inference. Malice is implied or presumed from the willful, deliberate, and intentional doing of an unlawful act without just cause or excuse. In other words, in its general signification, malice means the doing of a wrongful act intentionally without justification or excuse. Even if facts are proven and they're sufficient to raise a presumption of malice, such presumption could be rebuttable. It is for you, the jurors, to determine from all the evidence whether or not malice has been proved beyond a reasonable doubt. While malice is presumed from the use of a deadly weapon, whereas in this case the circumstances relating to murder are brought out in the evidence, the presumption vanishes and the burden is on the state to prove malice by evidence satisfying you beyond a reasonable doubt. We say malice aforethought. The law does not require that malice shall exist for any particular length of time before the act is committed. It must be aforethought. There must be a combination of a previous evil intent and the act producing the fatal result. I charge you further that the state is not required to prove any motive for the killing. Back to the portion of the charge dealing with your being the sole judges of the credibility or believability of the witnesses and the evidence, you may use your years of experience in dealing with your fellow man. Ask yourself as to this witness or that witness, is there any bias or prejudice present? What does this witness have to gain or lose by his or her testimony? You can believe one against many or many against one. I charge you that the defendant, by not having to prove her innocence, may or may not testify in her own defense. The fact that she did not take the stand in this case in her own defense cannot be used against her. An indictment for murder includes the lesser crime of unlawful homicide known as manslaughter. In other words, this defendant who has been indicted for murder may be convicted by you for manslaughter if the evidence warrants it. Manslaughter is the unlawful killing of another person without malice. You will notice that the absence of malice is what distinguishes manslaughter from murder. You are not concerned with involuntary manslaughter. I charge you a definition of manslaughter for the purpose of this case is the felonious taking of the life of another in either sudden heat and passion upon sufficient legal provocation. The law recognizes the fact that sudden heat and passion may, for the time being, affects one's self-control, temporarily disturb the sway of reason, and hence in law reduces the crime from murder to manslaughter. Sufficient legal provocation must be such as would be calculated to cause a man or woman of ordinary reason and prudence, sometimes described as an average person, to become enraged, that is, to experience sudden heat and passion, and hence to lose control of herself or himself temporarily. It frequently involves physical aggression or assault. Merely by way of illustration, and for that purpose only, I may say that when an unjustifiable assault is made with violence or with circumstances of indignity upon a man's person, and the party so assaulted kills the aggressor, the crime will be reduced to manslaughter if it appears the assault was resented immediately, or that the aggressor was killed in the heat of blood, for it will be observed that the killing must be in sudden heat and passion, and if passion had in fact cooled, or if there was sufficient time between the provocation and the killing for the passion to cool, the killing would not be attributed to heat of passion, but to malice. The question of intoxication has been raised, and it is necessary that I charge you on that. The state Supreme Court has ruled that it adopts the rule that voluntary intoxication, where it has not produced permanent insanity, is never an excuse for or a defense to crime, regardless of whether the intent involved be general or specific. Reason requires that a man who voluntarily renders himself intoxicated be no less responsible for his acts while in such condition. For the law to grant immunity for crimes committed while the perpetrator is in such a voluntary state would not only mean that many defenders would go unpunished, but would also transgress the principle of personal accountability, which is the bedrock of all law. The effect of drunkenness on the mind and on a person's actions is a fact known to all of us, and it is as much the duty of a man or woman to abstain from placing himself or herself in a condition from which such danger to others is to be apprehended just as much as it is to abstain from firing a gun into a crowd or doing any other act likely to be attended with dangerous or fatal consequences. I charge you that in this state there is a presumption that if blood alcohol level of 0.08 or above is present in a person, that person is presumed to be under the influence of alcohol. Okay, these are some drills on proper names for the record. The following speakers addressed the group of congressmen on the subjects indicated. Mr. Davidson Murtha, the Johnstown flood. Mr. Eric Schuster, campaign tricks. Mr. Mendel Davis, the use of CB radios. Mr. Floyd Corder, arbitrary bureaucracy and the Prudential Insurance Company. Mr. Wilton Gingrich, federal income tax reduction. Mr. Radford Zablocki, United Nations Mid-Decade Conference for Women. Mr. Brian Wolf-Moynihan Amendment. Mr. Edward Broomfield, United Nations Support. Mrs. Zelma Oker, appointment of a U.S. delegate to the Conference on Women. Mr. Victor Witten, agricultural rural development. These are numerical expressions for the record. The following hearings were scheduled for February 19. 11 a.m., case 53-690, Birch. 11:15 a.m., case 53-693, Hines. 12 noon, case 51-625, Riverset. 1:15 p.m., 67-496, Hoyle. 1:30 p.m., case 58-959, Wilson. 2:45 p.m., case 90-406, Stegall. The following hearings were scheduled for February 20. 9:30 a.m., case 79-4338, Jordan. 10:45 a.m., case 58-465, Usher. 11:15 a.m., 28065, Duke. 1:45 p.m., 75-482, Broome. 3:30 p.m., 15075, Oliver. 4:15 p.m., 30714, Shed. The following hearings were scheduled for February 21. 8:15 a.m., case 69035, Drayton. 9:45 a.m., case 44718, Stevenson. 10:15 a.m., case 41036, Benson. 11:30 a.m., case 65893, Gilbert. 2 p.m., case 7919529, Kelly. 3 p.m., 31587, Palmer. 4 p.m., case 19364, Riverdale. Okay, this is a short segment on bailment, and I will repeat it for the record. A bailment may be defined as a contract for the delivery of personal property for safekeeping and is a contract which is contemplated to be beneficial to both parties thereto. Where the bailment is reciprocally benefit to both parties, the bailee or the defendant is liable to the bailor or the plaintiff for the failure to exercise ordinary or reasonable care in the absence of a specific agreement to the contrary. The defendant was negligent if he or she failed to exercise the degree of care in protecting the plaintiff's property that an ordinarily careful and prudent person would have exercised under the same or like circumstances. If the defendant used ordinary care and diligence, then he or she is not liable. But if he or she failed to use the ordinary care and diligence that an ordinarily prudent person would have used under the circumstances, then he or she is liable. Okay, I will repeat that. A bailment may be defined as a contract for the delivery of personal property for safekeeping and is a contract which is contemplated to be beneficial to both parties thereto. Where the bailment is reciprocally beneficial to both parties, the bailee or the defendant is liable to the bailor or the plaintiff for the failure to exercise ordinary or reasonable care in the absence of a specific agreement to the contrary. The defendant was negligent if he or she failed to exercise the degree of care in protecting the plaintiff's property that an ordinarily careful and prudent person would have exercised under the same or like circumstances. If the defendant used ordinary care and diligence, then he or she is not liable. But if he or she failed to use the ordinary care and diligence that an ordinarily prudent person would have used under the circumstances, then he or she is liable.